It contains complex conflicts and sensitive situations. Viewer discretion is advised.
By 8:30 on a Tuesday night in late October, I was on my kitchen floor with my back against the lower cabinets, trying to understand why my legs would not respond to me. That morning before leaving for work, I had taken my prescribed muscle relaxant exactly as directed. 1 tablet, same dosage I had taken for years. I remember glancing at the clock on the microwave, swallowing it with a glass of water, and locking my apartment door in Southeast Portland like I did every weekday. By late afternoon, during a project update meeting at the engineering firm where I work, I felt a tremor in my hands. It was stronger than usual, but I finished the meeting. I have lived with a neuromuscular autoimmune condition long enough to know the difference between discomfort and danger. This felt closer to danger. I drove home carefully, both hands steady on the steering wheel. My sister Jenna had texted earlier asking if she could stop by. She lives 10 minutes away and has a spare key that our parents insisted she keep, just in case. I told her I would be home after 6. When she arrived, I was already leaning on the kitchen counter, waiting for the shaking in my thighs to pass. I tried to straighten up. My knees gave way. I caught myself on the edge of the counter, but my legs folded anyway. I slid down slowly, more embarrassed than afraid at first. Jenna stood near the refrigerator, arms crossed. She watched me attempt to push myself upright. "It's probably just side effects," she said evenly. "You always assume the worst." I was not assuming anything. I was trying to stand. I planted my palms on the floor and pressed down. My arms trembled. My legs felt disconnected like they belonged to someone else. I could not get my weight under me. The distance from the tile to the counter seemed farther than it should have been. I told her this was not normal for me. I have had flare-ups before, but not like this. Not this sudden. Not after a routine dose. She didn't reach for her phone right away. She suggested I wait it out. She said sometimes medication hits differently. She said I had been stressed lately. She said a lot of things. What she did not do was call for help. I felt my breathing change. Not panicked, but shallow. My neurologist has always been clear. If weakness progresses rapidly, do not ignore it. Do not assume it will pass. I asked Jenna to bring me my phone from the dining table. She hesitated, then handed it to me. My fingers shook as I unlocked it. I realized then that I could not rely on my body, and I could not rely on the person standing over me to decide whether this was serious. I dialed for medical assistance myself. As I sat there waiting, legs useless beneath me, I kept replaying the morning in my head. 1 tablet, same bottle, same routine. If I took my medication exactly as prescribed, why couldn't I stand by nightfall? That was the question I did not yet have the strength to answer. The ambulance ride blurred into white ceiling panels and the steady rhythm of monitored vitals. By 9:15 that Tuesday night, I was in the emergency department at Oregon Health and Science University. A nurse secured an IV line while another asked me to confirm my medications and dosage schedule. I answered each question myself. I have managed my condition independently for years. My name, my birth date, my prescription, the exact milligram strength. All of it was routine to me. Jenna stood near the foot of the bed. When the nurse asked who had been with me at home, Jenna explained that she had stopped by and that I sometimes struggle with side effects. She mentioned that she had helped me organize my pill box before when I felt overwhelmed. That part was not accurate. I do not use a pill box. I keep my prescriptions in their original bottles inside a locked drawer. The nurse typed steadily into the electronic chart. I watched the screen from an angle, aware that whatever was entered there would follow me long after this night ended. My parents arrived shortly before 10. They had driven in from Beaverton after Jenna called them. My mother pressed my hand and asked what had happened. Before I could answer fully, Jenna summarized the evening in careful, simplified language. She emphasized stress. She emphasized that medication can affect people unpredictably. I focused on the attending physician instead. He asked when the weakness began and whether this pattern had occurred before. I told him the tremor started mid-afternoon and escalated quickly after I got home. I told him this degree of sudden weakness was not typical for me after a stable dose. He ordered expanded blood work because the progression was rapid. He explained that when symptoms accelerate beyond baseline, they check for infection, electrolyte imbalance, and medication levels. His tone was measured. No one in that room treated this as dramatic. While we waited for results, I tried to sit upright without assistance. My legs remained unreliable. A nurse helped me shift position to prevent strain. That small gesture stayed with me. In that space, my body's limits were acknowledged as real. Jenna stepped into the hallway at one point to take a call. When she returned, she told my parents that the doctors were just being thorough. I recognized the phrase. It was the same one she used whenever I scheduled specialist appointments. Close to midnight, I was admitted for observation. The decision was based on weakness that had not resolved within the expected window. The admitting note listed acute exacerbation of neuromuscular symptoms pending laboratory clarification. As I was transferred upstairs, I understood something I had not wanted to name before. Inside my family, the story of my body was already being rewritten. In the hospital record, it was still mine. I woke just after 6 on Wednesday morning to the sound of a phlebotomist adjusting the blinds. The weakness in my legs had not resolved overnight. I could move them, but they felt delayed, as if instructions were traveling through water instead of nerves. A nurse checked my vitals and told me the first round of lab results had returned, but additional panels were still pending. By mid-morning, the attending physician came in with a tablet in his hand. He reviewed my electrolyte levels first. Normal. No signs of infection. Kidney and liver function within range. He moved on to medication levels. The serum concentration of my prescribed muscle relaxant was higher than expected for a single standard dose taken that morning. Not dramatically toxic, but above the therapeutic range documented in my file from prior visits. He paused long enough for me to register that detail. He then mentioned something else. The toxicology screen had identified a secondary sedative in my bloodstream. It was not listed anywhere in my medication history. It was not a drug I had ever been prescribed. He asked me directly whether I had taken anything else. Over-the-counter sleep aids, herbal supplements, a leftover prescription from years ago. I told him no. I am careful with what I put in my body. My condition requires it. He documented my denial in the chart and ordered a confirmatory test to rule out lab error. He explained that false positives are possible, though uncommon. The confirmatory test would use a more specific analytic method. Jenna was in the room for part of this conversation. She shifted in her chair when the sedative was mentioned. She suggested that perhaps I had forgotten something I took. Stress, she said, can affect memory. The physician did not respond to that. He asked me again privately this time once she stepped out to take another call. I repeated that I had taken only my prescribed dose that morning. Shortly after noon, the confirmatory results came back. The sedative was verified. The quantitative level was low but clinically relevant, especially combined with an elevated concentration of my regular medication. The physician explained that the combination could amplify muscle weakness and impair coordination. He made a note that the clinical picture did not align with routine side effects from a stable regimen. He also recommended that any remaining tablets from my current bottle be retained for analysis rather than discarded. That recommendation changed something. Until that moment, the explanation could still have lived inside my body. An unusual reaction, a rare interaction, an error in metabolism. Now the focus shifted outward toward the source of the pills themselves. Later that afternoon, a nurse brought in a small evidence bag and asked me to list any medications I had at home. She explained that if there was concern about contamination or incorrect dispensing, the pharmacy would need the specific lot number and remaining tablets. I gave her the pharmacy name, the location, and the fill date from memory. I have always tracked those details. When Jenna returned to the room, she looked at the plastic bag on the bedside table and asked what it was for. I told her the doctors wanted to review the medication. She said that sounded excessive. But the numbers in the report were not excessive. They were precise. By early evening, the plan was clear. I would remain admitted for observation while my strength was monitored. Once discharged, I was to bring the bottle directly to my licensed pharmacy without altering its contents. As the day ended, the narrative inside the hospital chart had shifted again. My symptoms were no longer categorized as unexplained flare. They were linked to measurable discrepancies. I did not yet know how those discrepancies had occurred. but they were documented, time-stamped, and no longer theoretical. I was discharged late Thursday afternoon with instructions to avoid driving until my strength stabilized and to bring the remaining tablets to my pharmacy without altering the contents. My mother drove me back to my apartment. Jenna did not come. The hospital summary listed medication irregularity under evaluation and recommended close monitoring. It was clinical language, but it carried weight. Inside my apartment, nothing looked disturbed. The mail sat where I had left it. My laptop bag was still on the dining chair. The medication bottle was on the small shelf near the hallway where I keep it out of direct sunlight. I washed my hands, sat at the dining table, and placed the bottle in front of me. I unscrewed the cap carefully. The tablets looked the same at first glance. White, oval, scored down the center. I went to my bedroom and unlocked the drawer in my desk where I store backup refills. I keep at least one unopened bottle in case of insurance delays. I set the unopened bottle next to the current one and poured a few tablets from each onto separate napkins. The difference was subtle, but present. The imprint on the backup tablets was sharper, the coating slightly glossier. The current tablets had a faint chalkiness to them that I had not noticed before. I checked the labels. Same pharmacy chain, same location on Southeast Division Street, same prescribing physician. The lot number on the current bottle matched the receipt stored in my email from 2 weeks earlier. I did not draw conclusions. I took photographs of both sets of tablets under the overhead light and noted the date and time. The next morning, Friday, just after 10, I had my mother drive me to the pharmacy. I brought the bottle in its original container and told the pharmacist that my hospital labs showed an unexpected medication level and a sedative I did not take. He led me to the consultation counter. I handed over the bottle. He scanned the barcode and pulled up my dispensing record. The prescription had been filled correctly according to their system, 30 tablets, correct dosage verified by 2 staff members at the time of dispensing. He opened the bottle and examined one tablet under the small magnifier attached to the counter. He compared it to a reference image in his database. He did not comment on appearance beyond noting that manufacturers sometimes vary coatings slightly between batches. I told him the hospital had recommended independent analysis of the remaining pills. He nodded and explained the process. The tablets would need to be transferred under documented chain of custody. They could coordinate with my prescribing physician to send them to a certified laboratory for content verification. He printed a receipt acknowledging temporary transfer for testing and asked me to sign. I did. My mother signed as witness. As he sealed the tablets in a tamper-evident bag, I realized that whatever was wrong would not be explained by assumption anymore. It would be tested. When we left the pharmacy, my mother asked whether I was certain this was necessary. I told her the hospital had advised it and that I was following medical guidance. By that evening, my physician's office had confirmed they would submit the tablets to an independent lab contracted for toxicology verification. I received the confirmation through the patient portal, time-stamped and documented. The problem had moved beyond my body. It now sat in a sealed evidence bag with my name on it. The lab report arrived the following Tuesday afternoon through my physician's secure patient portal. I was back at work by then, moving carefully between conference rooms, still aware of the lingering weakness in my legs. When the notification appeared on my phone, I stepped into an empty office and opened the document. The first page confirmed what the hospital had already suspected. The tablets from my current bottle contained a higher concentration of the active compound than labeled, not a minor manufacturing variation. The deviation exceeded acceptable pharmaceutical tolerance. Below that, in a separate line item, the report identified measurable traces of the same sedative found in my bloodstream. The lab methodology was listed. Batch numbers were recorded. The findings were not ambiguous. I read the document twice before moving to the attachments. The second file was a copy of the medication reconciliation form that had been scanned into my hospital record the night I was admitted. It was a standard hospital document allowing a patient to authorize assistance with medication management. My name was printed correctly at the top. My date of birth was accurate. The signature at the bottom was not mine. Next to the signature line was a notation, "Family representative authorized to assist with medication oversight." The handwritten name beneath it was Jenna's. I zoomed in on the signature. It resembled hers, but the slant and spacing were inconsistent with other documents I had seen her sign. The date on the form matched the evening I was brought into the emergency department. I called my physician's office and asked to speak with the compliance liaison. She returned my call within the hour. She confirmed that such forms must be signed either by the patient or by a legally designated healthcare proxy. No proxy designation was on file for me. She explained that the form had been uploaded to my electronic chart during intake. The staff member who scanned it would be identified as part of their internal review. She also stated clearly that if a non-patient signature was entered without proper authority, that constituted a serious violation of hospital policy. After that call, I sat with both documents open on my screen, the lab confirmation of altered medication and the unauthorized authorization form bearing my name. Up to that point, the explanation could still have rested on error, a dispensing mistake, a mislabeled bottle, a rare contamination. The presence of the sedative in the pills and my bloodstream was one issue. The presence of Jenna's name on a document granting control over my medication was another. I printed copies of both reports and placed them in a folder. For the first time since that Tuesday night, I understood that this was no longer just a medical irregularity. It involved access authority and representation, and my name was written on something I had never agreed to. I did not confront Jenna when I left work that Tuesday. Instead, on Wednesday morning, I scheduled a consultation with a criminal defense attorney whose office was downtown. I brought the lab report, the medication reconciliation form, and the pharmacy transfer receipt. I laid them out on the conference table in the order they had occurred. He read everything carefully before asking me a single question: had anyone else had access to my medication? I told him about the spare key my parents insisted Jenna keep. I told him she had been in my apartment the evening before I collapsed. I told him she had described my symptoms as side effects before the lab results existed. He did not offer dramatic commentary. He explained that altering prescription medication and signing a medical authorization without consent could fall under criminal mischief, involving prescription drugs and identity-related forgery. He also clarified that allegations would need to be supported by documented evidence, not suspicion. We discussed options. I could request the hospital handle the signature internally as a policy violation and stop there. Or I could file a formal police report and allow the district attorney's office to evaluate whether criminal charges were warranted. I went home with the documents still in my bag and did not decide that night. On Thursday afternoon, the hospital's compliance liaison called again. She informed me that the scanned authorization form had been uploaded during intake by a registration clerk who believed it to be valid at the time. The original paper copy was no longer in the physical intake folder. They could not confirm how it had been completed before being handed to staff. That absence changed the calculation. The next morning, I returned to the attorney's office and signed an engagement agreement. We drafted a formal statement describing the timeline, the dose taken, the onset of symptoms, the lab findings, the pharmacy transfer, and the unauthorized signature. That afternoon, we went to the Portland Police Bureau's Central Precinct to file a report. I provided copies of every document. The officer logged the complaint under suspected prescription tampering and falsification of a medical record. He explained that the case would be forwarded to detectives for review. There was no immediate arrest, no visible shift in power, only paperwork and a case number written on the top of my copy. Later that week, I received confirmation that detectives had requested handwriting samples and would seek a warrant to review Jenna's phone records for relevant search history. The process would take time. A judge would need to approve any search warrant. When my parents learned that I had filed a police report, they came to my apartment without calling first. My father asked whether I understood the seriousness of what I had done. My mother asked whether this could still be handled privately. I told them the hospital and the lab had documented measurable discrepancies. I told them that my physician had recommended further review. I told them I was following medical and legal guidance. Jenna did not contact me directly that week. Instead, I heard from a cousin that she believed I was escalating a misunderstanding. I did not respond to that version of events. By the end of the week, the conflict had moved beyond family interpretation. It had entered a formal record. I still did not know how the investigation would unfold, but the decision to involve law enforcement meant it would not disappear quietly. The following Monday, a locksmith changed the deadbolt on my apartment door. I scheduled the appointment myself and paid for it with my own card. The spare key my parents had insisted Jenna keep no longer worked. The locksmith handed me 2 new copies and watched as I tested the lock from both sides. That same afternoon, I logged into the hospital's patient portal and uploaded a notarized designation naming a neutral healthcare proxy. A colleague from work, someone with no family ties to me, agreed to serve in that role if needed. I also submitted written instructions restricting all access to my medical information unless I provided direct consent. The compliance office confirmed receipt. My chart would now require verification of my identity before any information was released to anyone else. No informal assurances, no verbal permissions. I did not announce these changes to Jenna. She found out when she attempted to log into my account from a previously saved device and was denied access. Later that evening, my mother called to say Jenna was upset and felt cut out. I told my mother the access had never belonged to her in the first place. 2 days later, an email circulated within our extended family group. It did not name the criminal report directly, but it referenced overreactions and destroying trust over assumptions. The language was careful, but the implication was clear. At work, my supervisor asked whether I needed additional leave. He had heard from a mutual acquaintance that I was dealing with family legal issues. I assured him I was able to manage my workload. Still, the fact that my private medical situation had become a topic outside my control was not lost on me. By the end of the week, I had also installed a small security camera near the entryway of my apartment. It recorded only the door and immediate hallway. I did not advertise its presence. I simply wanted a record of who entered and when. Detectives contacted my attorney to confirm that handwriting samples would be collected formally rather than informally. The warrant request for phone data was still pending judicial review. Nothing moved quickly. In the meantime, the social cost accumulated. My father stopped returning my calls. A cousin I was close to texted to say she hoped I would reconsider before it went too far. It had already gone too far, not because of the police report, not because of the investigation, because someone had signed my name on a document granting control over my medication. Changing the lock and restricting access did not resolve anything legally. The case was still under review. The evidence was still being processed. But those steps altered something immediate and concrete. For the first time since that Tuesday night, I controlled who could enter my home and who could speak for me in a medical setting. The distance between Jenna and me was no longer theoretical. It was built into the hardware of my door and the permissions on my chart. 3 weeks after I filed the report, my attorney called on a Thursday afternoon to say a judge had signed the warrant. Detectives had obtained authorization to review Jenna's phone data for a limited time frame surrounding the days before and after my hospitalization. The scope was specific search history messaging related to medication and location data tied to my address. The warrant did not mean guilt. It meant a court had determined there was sufficient probable cause to examine digital evidence. A week later, my attorney and I were notified that the preliminary digital review had identified multiple searches on Jenna's device in the days leading up to my collapse. They included phrases about altering prescription tablets without visible residue and about sedatives that metabolize quickly. There were also text messages between Jenna and an unidentified contact discussing adjusting dosage and making it look consistent. The messages were not addressed to me. They did not contain my name, but the timestamps aligned with the period when my medication was filled and when she had been in my apartment. The district attorney's office scheduled a meeting with me and my attorney to review the findings in person. The assistant district attorney explained that the evidence would need to be authenticated and that any charges would depend on corroboration from the lab analysis and hospital documentation. They were careful in their language. No conclusions were announced. No promises were made. Later that week, detectives collected a voluntary handwriting sample from Jenna in the presence of counsel. A forensic document examiner would compare it to the signature on the hospital authorization form. That process would take additional time. Meanwhile, the pharmacy's corporate compliance department contacted my physician to request the independent lab's full report. They opened their own internal investigation into possible tampering after dispensing. The situation was no longer contained within one institution. It now involved law enforcement, a forensic examiner, and a corporate compliance unit. At home, the security camera recorded a single attempted entry one evening just after 9. The doorknob rattled once, then stopped. The footage showed no face, only a partial frame of a sleeve before the person stepped out of view. I saved the clip and forwarded it to my attorney without commentary. 2 days later, a detective asked whether I had experienced any direct contact or intimidation. I told him about the attempted entry and the family emails. He added it to the case notes. For the first time since the investigation began, I felt the structure of it working independently of my emotions. Each piece of information was being processed through a formal channel. I did not know what the charging decision would be. I did not know how the family fallout would settle. But the narrative that I had overreacted was no longer the only one on record. There were search terms. There were timestamps. There was a signed warrant. And there was a growing file with my case number on it. The call came on a Wednesday morning nearly 2 months after the night I was admitted to the hospital. My attorney asked if I could come to the district attorney's office that afternoon. The forensic document examiner had completed the comparison. The digital evidence review was finalized. A charging decision had been made. We met in a small conference room overlooking downtown Portland. The assistant district attorney outlined the findings in measured terms. The handwriting analysis concluded that the signature on the hospital authorization form was highly consistent with Jenna's known writing samples and inconsistent with mine. The independent lab confirmed that the tablets contained both an excessive concentration of the prescribed compound and the sedative identified in my bloodstream. The pharmacy's internal investigation found no evidence of manufacturer error or dispensing mistake. Based on the totality of evidence, the state was filing charges for prescription drug tampering and forgery related to a medical record. The case would proceed through the Multnomah County Circuit Court. There was no spectacle attached to the announcement, just documentation and a scheduled arraignment date. Later that week, Jenna was formally served with the charges. She was not taken into custody at that moment, but was required to appear in court. Conditions of release were set, including no direct contact with me and no attempt to access my medical records. My parents called the evening after the arraignment. My father asked whether I would consider declining to cooperate. He said a conviction could permanently affect Jenna's career prospects. My mother said families should handle conflict without involving the state. I told them the state had made its own determination based on evidence. My role was to respond truthfully when asked. The following Monday, I attended the arraignment hearing. Jenna stood at the defense table beside her attorney. She did not look at me. The judge reviewed the charges, confirmed her understanding of them, and set future court dates. The no-contact condition was entered into the record. It was not a dramatic moment, no raised voices, no public humiliation. But something fundamental shifted. The claim that this had been a misunderstanding was now formally contradicted by the state of Oregon in open court. As the hearing ended, she finally looked at me. For what she asked, quietly. For the record, I said. Not for revenge. Not for punishment. For the fact that my body had not failed me. Someone else had. Jenna's access to me, to my records, and to my home was no longer governed by family expectation. It was governed by court order. I left the courthouse aware that the case was far from over. There would be motions, negotiations, and possibly trial proceedings. The outcome was not yet decided. But for the first time since my legs gave out on that Tuesday night, the question of whether something had been done to me was no longer up for private debate. It was a matter before a judge. The case did not go to trial. 4 months after the arraignment, Jenna entered a negotiated plea in Multnomah County Circuit Court. She pleaded guilty to 1 count of prescription drug tampering and 1 count of forgery related to a medical record. The court dismissed a secondary charge as part of the agreement, but the core offenses remained on record. The judge reviewed the lab findings, the forensic handwriting analysis, and the documented search history before accepting the plea. Jenna was sentenced to supervised probation for 3 years, required to complete a substance abuse and decision-making evaluation, and ordered to have no contact with me for the duration of probation unless modified by the court. She was also ordered to pay restitution covering my hospital deductible and legal expenses tied directly to the incident. There was no jail sentence. There was no dramatic exchange in the courtroom. There was a conviction entered into the state record. The pharmacy concluded its internal review separately. Their report confirmed that the medication left the store within regulatory standards and that the alteration occurred after dispensing. They implemented additional documentation requirements for high-risk prescriptions, and I received a written acknowledgement of the findings. The hospital compliance office closed its investigation with a formal policy revision. Intake staff would now require direct patient verification for all authorization forms unless a pre-filed proxy existed. I was notified in writing that the unauthorized form had been permanently flagged in my chart and could not be used for future access. My parents did not attend the plea hearing. My father sent a brief message saying he hoped time would heal this. My mother did not contact me at all. I did not respond to either. The no-contact order remained in effect. It extended beyond personal communication to any attempt to access my records or my home. Violating it would carry additional penalties. In practical terms, that order changed my daily life more than the sentence itself. I no longer checked my phone expecting pressure. I no longer wondered who might appear at my door. 6 months after the plea, my neurologist adjusted my medication back to a stable baseline. My strength returned gradually, and the tremor that had followed the overdose episode subsided. At work, the rumor cycle ended as quietly as it had begun. My supervisor evaluated me based on performance, not family litigation. I received a routine merit increase at the end of the fiscal year. The legal process did not restore my relationship with my sister. It did not repair my parents' disappointment. What it restored was a clear public record. When my legs gave out that Tuesday night, I did not have control over what had been put into my body. I did not have control over who was speaking for me in a hospital room. Now there is a court order, a conviction, and a medical file that reflects exactly what happened. The record stands whether anyone in my family agrees with it or not. The week after the plea was entered, I requested a certified copy of the court docket from the Multnomah County Circuit Court. It arrived by mail in a thick envelope stamped with the state seal. Case number at the top, charges listed beneath it, disposition guilty. The document did not describe emotions. It did not describe family conflict. It did not speculate about intention. It recorded dates, findings, and a conviction entered into public record. I placed the certified copy in the same folder as the hospital lab report and the flagged authorization form. 3 documents, 3 timestamps, 1 version of events that no one could edit after the fact.